Now, David has challenged me. He said, there's nothing more boring than giving the ethics presentation. And he said, I want to see how you keep the audience. And I said, that's awfully presumptive of you that if I'm going to, in fact, keep the audience. So I'm going to try my best. I'm going to speak from my outline. I'll try to let you know where I am on it. This, again, is obviously a very difficult topic. It's always difficult to talk about ethics to lawyers because we know what to do, right? We know exactly how to do it and exactly how to do it correctly. So God forbid that somebody like I would stand up and say maybe a few things might need to be tweaked. But it's particularly difficult in terms of representing clients with diminished or diminishing capacity, which is the clientele that I know many of you have, because the rules don't apply. The rules that are written in the Model Rules of Professional Conduct were basically written by litigators for litigators. And it's really easy to tell when you're litigating if you have a conflict of interest. Two guys come in, they're both accused of the same crime, they both say the other one did it. Hey, you can't represent both of those. That's easy. But then when you have families coming in, when you have multiple generations coming in, it's hard to distinguish sometimes who your client is and whom you really represent. And then we add on this complexity, this additional layer of perhaps that person may not have the capacity necessary for the transaction. So I'm beginning not hopefully to reiterate anything that was said yesterday, because I know you had some great talks yesterday, but just to remind you that what we're talking about, what I'm talking about, is the legal landscape of capacity. And I know Vicki and I were just talking about the fact that there's a medical landscape to capacity, and it's really difficult to get the two players to speak to each other about that. But from the standpoint of a legal determination, we have to remember that this is a determination that is made by the lawyer. It's not a determination made by anyone else, though certainly the experts can help us. It can have criminal law ramifications. It can have civil law ramifications. We travel under the assumption legally that a person has capacity, and so things would have to work down from there. The nice thing that we've finally realized in recent years is the capacity is not on or off. You don't switch it on or off. So tomorrow morning, hopefully, I will not wake up and lack capacity. It's on a sliding scale, and again, that's part of what makes it so difficult for us as lawyers, because the capacities for certain transactions are also on a sliding scale. I know you know that there's a very low level of capacity required to make a will, but then that capacity starts to get ratcheted up when you start to make inter vivos transfers, enter into contracts, and of course there's that added background of whether the client even has the capacity to enter into the relationship. Now, at some point, I hope I will get to page 32, but if I don't, just mark it down, because there are about 15 tips there on how you as the lawyer can help maximize your client's capacity. There are ways in which we can work with a client who perhaps might be suffering from some diminishing capacity, but still has a capacity to do something that's very important for the client. In extreme cases, unfortunately, we find ourselves as lawyers having to take what's called protective action. And again, the model rules aren't particularly helpful there, but I'll talk about how they guide us. Now, I will focus on the model rules, but I'm a Georgia lawyer, and Georgia's rules of professional conduct are slightly different. So when I see a difference that I think is important, I'll point it out to you. I'll also be giving you some quotes from the ACTEC commentaries. Now, what ACTEC, the American College of Trust and Estate Counsel, did was to go back into the model rules and the comments and try to translate them for counselors, for people like you, people who have people coming into their offices not for litigation purposes primarily, but mostly for advanced planning. And so I'll talk to you about some of the things in those commentaries. I'm quoting the 4th edition. As of April, there will be a 5th edition. It's on the ACTEC website, accessible to anybody, so please go check it out. I'll also talk about the NAILA aspirational standards for the practice of elder law. NAILA, too, is in the process of revising these, and I've been lucky enough to be on the committee to do that, and there's some very, very, very distinct and subtle differences between the way that they are approached in the current standards, that problems are approached, and the way that they will be in the new standards. You'll probably see those new standards in September. Another important resource for you, if you don't already have it, the American Bar Association and the American Psychological Association have put together 3 handbooks. They're basically called Assessment of Older Adults with Diminished Capacity. And I've got the full name on page 2 of the outline. There's a handbook for lawyers, there's a handbook for judges, and there's a handbook for psychologists. These are must read. They are so helpful, and they have so many helpful forms. They, too, hopefully will be updated soon, because a little bit of some of the things in there are getting a bit out of date. I'll talk to you about some state laws, maybe not Georgia state laws, some cases, maybe some rulings from other states, just to give you an idea of what people are thinking about in this context, about an ABA ethics opinion, which is really important. Another book for your shelf is called Ethics in the Practice of Elder Law. That's by Becky Morgan and Roberta Flowers, again, two giants in the field. And the ARP also has a pamphlet that's they've recently distributed about protecting older investors. So finally, I think people are paying attention to diminished capacity. So before I go into the details of the really boring part, which is the rules themselves, let's talk just a little bit more, just a quick reminder about what the medical or psychological landscape might look like, and then how we as lawyers work across that landscape to figure out if legal capacity is there. Now again, just as in the legal field, medical field realizes that capacity is not on or off. Importantly, what they tell us is that it can be temporary. It can be situational, it can be partial, and it can be treatable. So we mustn't travel under the assumption that just because somebody comes in the office who is manifesting what we think are signs of diminished capacity, that the case might be hopeless. So it's important to look at some of the potential causes of what we're seeing. An important resource that we need to keep in mind is that we can, either ourselves as lawyers or via our clients, have access to people who are skilled forensically in deciding whether somebody has capacity. Now, I think the first reaction often of people when they're worried about their client is to suggest that the client go to the client's personal physician. I've had personal physicians tell me on several occasions that's not necessarily the best idea. I already saw somebody shaking her head over there, because the personal physician is in a therapeutic position. The personal physician is not going to be inclined to want to write out a formal assessment that says this person doesn't have X capacity. On the other hand, there are people who are actually trained as forensic evaluators. These are neutrals. These are people whom you want to get to know in your neighborhood, because you and they can talk about evaluations. And again, the forensic evaluator can very likely give you a more neutral evaluation, and that one will probably be more helpful if you need it in the long run. Now, these evaluators use all sorts of tests. And just to give you a few illustrations on page 4 of the outline, they use a clock drawing test. The clock drawing test, they will give the client, the patient, in this case a circle, and ask the patient to write in all the numbers and then set the hands of the clock at a certain time, 1:45 or something like that. Well, if you've got your outline handy, you can see how quickly a diminishment in capacity can show up on one of these clocks. They also use naming tests, so they have a series of items that are going from the very simple, like a banana, to something maybe a little bit more complicated, like a motorcycle. And again, we'll have people go through the names. But keep in mind that, and they, I believe, are starting to realize this, that these tests can be culturally different. So for example, the picture on the bottom of the page, on page 4, most people look at that and say, oh, that's an igloo. Well, one forensic evaluator said he got taken aback a few minutes because his patient said, oh, that's an oven. And he stopped for a minute, and then he realized she had grown up in Mexico. The adobe clay oven looks just like an ice igloo, so who knew? Okay, and the generational issues on the next page. My greatest teacher in this field was my 95-year-old mother-in-law. And boy, she was great. And I'll tell you stories about her. Her name's Alta, because she, as I said, taught me a lot. But I am absolutely positive she could recognize the top picture on page 5 as a phone. If somebody showed her that bottom picture, what we call phones today, she would have no idea what it was. In fact, I remember handing her my cell phone at one time, and she looked at it, and she shook it, and then she looked at it again, and then she threw it away. Okay, so she's, enough of that. That was kind of her reaction to anything that she didn't like. I'm going to skip through much of this because I know you've seen it already in this seminar. I'm going to go over to page 7 and talk about some of the things that might be causing the incapacity that you're seeing when people come into your offices. Delirium and confusion. Now, the important thing about delirium and confusion is it's probably, very possibly, temporary and treatable if it's identified early on. And the simplest things can cause this delirium or confusion. Drug interactions, an electrolyte imbalance, dehydration, malnutrition, infection, a vitamin B12 deficiency. There's lots now about vitamin D deficiencies. So all of these things are things that, in fact, if they're identified, could easily be treatable. You might see clients who come in with a decreased awareness of their surroundings. Maybe they're disoriented. Their thinking skills are a little slower or poorer than perhaps you would have expected. Maybe not good memory of recent events. Rambling. Sometimes they have difficulty understanding speech. Some behavioral changes, maybe combativeness or agitation. My favorite story, I'll give you my favorite story first about Alta. Alta was a perfect Southern lady. I mean, she knew what day of the year you started wearing the white gloves. She knew that her purse and her shoes always matched, and she never cursed. Shut up to her would have been a cursing. So as she, as I refer to it now, as her filters started to wear down over time, she got a little bit less of the Southern lady and a little bit more of the person she probably really was. And my husband and I came into the nursing home to see her one day, and I leaned down to kiss her, and she said, "I don't know who you are, but you look like a bitch to me." So, as you did, my husband thought that was really funny. So she looks up and she says, "And who's that old man you're with?" I thought, yeah, okay, great. So we're going to see behavioral differences. One thing that I did discover with her, and I know you've seen it a lot in your clients, is that things like that Southern politeness, those may mask what is in fact a lack of capacity. Because my father, for example, he was so much the showman. He was always polite, always happy, always making people feel good, that it took us some time to realize that that was really an act he memorized years and years ago, and it was not a sign that this was in fact what we refer to sometimes as a good day. Okay, the incapacity that you're perceiving might be caused by mental illness, by intellectual or developmental disorder, even a physical illness, vision, hearing. Those are sometimes interpreted by lawyers as being signs of incapacity, which they really are not in the legal sense. Physical frailness or an organic brain damage, alcohol or drug dependency. Depression is, according to the CDC, the Centers for Disease Control, and there's something else, and I can't remember what the end of their title is. They cite depression as the most common mental disorder among older adults. But they also tell us that 80% of people with depression can be treated. So again, we need to know this as background so that we won't dismiss someone or not help a person to achieve a goal that person, in fact, might have the capacity to achieve. Of course, the 800-pound gorilla in the room is dementia. Dementia, which the new term neurocognitive disorder, which really didn't catch on, and it hasn't with me, so I'll be talking about it as dementia. I don't need to tell you the statistics. You know how as the older a person gets, the possibilities are so much greater. Some other risk factors besides advancing age are family history, education even, poor physical health, and the so-called Alzheimer's gene. The psychologists have divided dementia into stages now, and those stages are set out for you on pages 7, 8, and 9, and I'm not going to go through them right now. But what's important there is to know that this is a progressive disease, and it can last for a long period of time. Again, I think our society, through movies like Still Alice, is becoming more and more familiar with the effects of this disease. It's actually, I referred to it as a disease. That was not correct. It's not a disease. It's a combination of an associated group of symptoms, if you will. Alzheimer's accounts for about 60 to 80% of the dementia that we see. Alzheimer's can affect emotions, as I pointed out. It can affect personality. And there will be people who are living a long time with it. Now, on page 11, the 10 warning signs of Alzheimer's. My temptation is to say, don't read these, because every one of us will see at least one on this list that we know belongs to us. And I used to laugh, and I say, oh, yeah, I see a few things on there. And then in 2013, the Alzheimer's Association came out with something called subjective cognitive decline, saying that a person's own sense that his or her memory skills are slipping is one of the first and probably most accurate signs that Alzheimer's may be setting in. So what are you going to see in your clients? You're probably going to see them missing appointments or frequently making calls and repeating the same things they've asked for before, being confused about instructions, repetitiveness, and difficulty recalling their past decisions. So I've probably told you more than I know about the medical aspect. Let's go back to the legal aspect. And we start with this term, diminished capacity. It's a term that's relatively recent in the field. If you had been reading old guardianship cases, which I did when we were putting together our guardianship code, you would see that even statutes contained words like idiots and lunatics. Lunacy hearings were not uncommon in Georgia very late into the 20th century. Under Old English law, an idiot was not the same thing as a lunatic. An idiot was a born fool. That is someone who was born as an idiot. A lunatic was someone who developed lunacy later in life. And of course, that was the moon, as you know, Luna, caused this. And the important thing was that the king could seize the land of an idiot, but only administer the land of a lunatic. So I have this vision of myself arguing that, no, my brother's a lunatic, Your Honor. You don't understand. He's not an idiot. He's actually both, but that's a different story, okay? So what do we say in the law? Well, we don't say much. In Model Rule 1.14, which is the rule, of course, that's supposed to cover this area, the rule just says when a client's capacity to make adequately considered decisions in connection with representation is diminished, whether because of minority mental impairment or some other reason, ta-da. Now, in the comment to that rule, comment 6, they do tell us there are certain things that we should look to figure out if the client's capacity has diminished. I'm on page 12 now. We want to see if the client can articulate reasoning leading to a decision. Again, the key for legal incapacity is decision-making. That's what we're worried about. We're not worried about whether someone can dress herself. We're not worried about whether someone can feed herself. From the legal standpoint, we are focused on decision-making. So we want to see if the client can articulate the reasoning leading to a decision, if there's variability in the client's state of mind or the client's ability to appreciate the consequences of the decision. The substantive fairness of a decision is one of the things on the list, but as we will see, and I'll point out several times, never let that alone be an indication to you that someone lacks capacity, because you may be imposing your own value judgment in terms of the substantive fairness of the decision. And if you've known the client for a long time, how consistent is this decision with past decisions and values that the client has shown you? There are several different ways to define diminished capacity, and on pages 12 and 13, I give you lots of different examples from different laws in different states. Georgia's guardianship law focuses, as I said, on decision-making capacity. It's the inability to make significant, responsible decisions about either one's personal safety, which would mean you need a guardian, or one's finances. So the model rule is really a study in contrast. The first thing that it tells us, which is good but difficult to maintain, is that even if the client's capacity is diminished, and I prefer to think of it as diminishing, and David, I applaud you on the name of this conference, that we focused on diminishing as well as diminished capacity. The rule says even if the capacity is diminished, the lawyer, as far as reasonably possible, is supposed to maintain a normal lawyer-client relationship. Well, what does that mean, a normal lawyer-client relationship? Well, that's where we pull in all these other model rules, and the first one is the client directs the representation. That's Model Rule 1.2. So again, even if your client appears to be suffering from diminished capacity, your duty is to strive first to abide by the client's decisions, not the decisions of the family member, not the decisions of the caretaker. And even the ABA opinion that's so important in our field, ABA 96-404, which I'll be quoting throughout here, even here, the opinion says that just because a client is making what you consider to be ill-considered decisions, that doesn't mean that the client is not reasonably able to act in his or her own interest. And you should not seek protective action solely to protect what you think, against what you think are errors in judgment. I gave a talk last week about one of my favorite topics, which is defending my right as an older woman to be eccentric. And we were talking about the fantasies that some older women and older men, but it was a women's conference, so the fantasies that older women engage in. And we talked about Huguette Clark, and I'm sure many of you have heard the story of Huguette. She had, when she died at 104, 1,157 dolls in her collection, many of which had Dior clothes and Givenchy clothes that she had bought for them. She had 3 Park Avenue apartments that were furnished for the dolls, beautifully furnished. She was living in a hospital room by choice. She had one of her agents go visit the dolls and come back and give her reports and photographs. And she gave her, God forbid, most of her property to non-relatives. So, of course, when the non-relatives, after she died, wanted to challenge the will, the dolls were exhibit number one, this huge collection. We need to keep in mind that people have the right to be eccentric. She was extraordinarily wealthy. She could afford to do this. The case settled, so we don't know what a jury would have decided about whether she had capacity. But I always think of that in terms of fantasy football. Okay, some 35-year-old guy is spending all of his time and perhaps money. I know you never bet on this, that's illegal, but all of his time and some money in fantasy football. And we're like, okay, that's fine. But if an older woman spends all of her money or much of her money building her doll collection, then people start to question her capacity. So again, it's the client who directs the representation as close as possible. Even the model rule tells us, even if a guardian's been appointed, the attorney for the client is to look to the client if possible. And I'll show you a couple of North Carolina cases that talk about that. The other thing is to maintain communication. The Model Rule 1.14, referring back to Model Rule 1.4, says as close as possible, communicate with the client. Speak to the client. I know it's a common tendency, particularly if somebody might have a little bit difficulty understanding, and there's a caregiver or a relative there, to look to the relative and to talk to the relative. This forces us, hopefully, to maintain our focus on the client. Model Rule 1.6, maintaining client confidences. This is where things are most difficult. Because you have a client, remember the rule, which is much broader than the privilege rule. The rule says anything that you learn in the course of the representation, you must keep confidential. Well, Model Rule 1.14 has a comment to it that bothers me a lot. It says the client may wish to have family members or other persons participate in the discussions. When necessary to assist in the representation, the presence of these people generally does not affect the applicability of the attorney-client privilege. No case has ever tested that. You know what happens if you if you have somebody else present in a conversation. It's not a privileged conversation anymore. So that conversation can be used against your client, perhaps in an incapacity hearing at some point in time. Georgia's rule is better, I think. Georgia says, when necessary to assist in the representation, the lawyer should consider such participation in terms of its effect on the attorney-client privilege. So the Georgia rule seems to indicate there may be a problem here. The one thing I will say to you, and this often happens, you know it better than I because you see more clients, is that when you have somebody else whom you do think is necessary to assist in the representation, document that. Document that. The only case that I've ever seen where a person was deemed necessary to assist in the representation was when an individual came in and his son was his translator because he didn't speak English. So if for some reason you feel that person needs to be there, be sure to document it. Let's go over to page 17. This North Carolina formal ethics opinion, I think, is a great illustration of how important it is and how difficult it is at times to make sure that you stick with your client, that you know your client is whom you represent. The lawyer in this case was actually contacted by the husband of a woman who was allegedly incapacitated. The woman had been removed from the family home. So the lawyer went to visit her and talked to her, and she indicated that she did want him to represent her. And she also said that she wanted to go home to live with her husband. She also reiterated in other contexts, in other conversations with the lawyer, that under no circumstances did she want to have a guardian. Okay, so there was a hearing, because remember, she'd been removed from the home. There was a hearing, and the State Department of Social Services claimed that the lawyer had no standing to speak on behalf of this client. And the lawyer stood his ground and said, yes, in fact, I do. Well, a guardian was appointed for her, and the lawyer appealed the appointment of the guardianship on her behalf. And once again, there was lots of talk by the DSS that your continued representation of this individual is inappropriate. Well, a formal ethics opinion was requested, and the opinion said that the lawyer in this case may continue to represent her alone, even if a guardian has been appointed for her, because this lawyer was absolutely convinced that the woman had the capacity to make the decision that she did not want to have a guardian, and in fact did not, in that particular circumstance, actually need that guardian. But that just shows you, again, how difficult it is, because the social services agencies, everybody is going to be saying to you, you don't have this right. It's very tough. This lawyer stood his ground, and I think, obviously, that's an important thing to do. But we've got the other end of the spectrum, and I know there are people in here who are very familiar with this, and of course, Kristen talked to you about it this morning, and that's elder abuse. We've got scams. We've got people out there who are hurting our vulnerable senior adults. So the other end of the spectrum on the ethical rule is Part B of Model Rule 1.14, and it says when the lawyer reasonably believes the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in her own interest, the lawyer may take necessary protective action. Evidently, there was a lot of debate as to whether that should be a may or a must, because some people wanted to say that it was the lawyer's duty, but the way the rule came out, the rule is just basically, you may take protective action. But, of course, it's not defined in terms of what it is. Well, that's going to cause an overlap with our Model Rule 1.6, because, again, you've learned a lot now in the course of this representation. It's supposed to be kept confidential, but if you take reasonably necessary protective action, you may end up revealing some of that information to somebody else. Have you violated your duty there? Well, the Model Rule 1.14c says that when protective action is needed, the lawyer is impliedly authorized to reveal information about the client, but only to the extent necessary to make sure that the protective action comes into play. And that's important, and it brings to mind that Model Rule 1.6 has rules that relate even if the client doesn't have diminished capacity. These are rules you probably remember because those are the ones they always emphasize, and that is if you, as the lawyer, have learned information in the course of the relationship, which otherwise should be kept confidential, but you reasonably believe it's necessary to break that confidentiality, in the words of the rule, to prevent reasonably certain death or substantial bodily harm, or to prevent the client from committing a crime or fraud, then you are allowed to reveal that information. Now, Georgia's rule, I think, is even better and more akin to what we're talking about here. Georgia allows you to reveal the information to avoid or prevent harm or substantial financial loss to another as a result of client criminal conduct or third-party criminal conduct. And that opens the door, again, if you are seeing the potential for third-party criminal conduct, abuse of your client, that may put you in a situation where you will be able to reveal some of the confidential information that you've learned. In New Hampshire, just last year, the New Hampshire Ethics Board, though, brought up another important thing for us to remember. To whom do we reveal the information? Well, there might be a family member that you feel could help in this particular situation. Often, though, people are obliged or feel obliged to go outside of the family, and perhaps they go to the doctor or the psychologist. Well, we need to remember that in every state there are mandatory reporting laws, and they're different in states. We don't know. In some states, even lawyers, if you can believe it, are required to report any suspected elder abuse. I think that really goes too far. It really oversteps the bounds of what we need, that confidentiality that we need in our attorney-client relationship. But this opinion points out that if you go to a specialist and talk to that specialist about your client, your specialist might then be required to report to the appropriate agency. And that might result in your client's freedoms being taken away. Maybe the client's going to be taken from her home, as was the case in our new North Carolina case, or there might be some guardianship proceedings begun. So it's a very, very delicate balance, very difficult when you're trying to protect from what you perceive potential harm, and yet at the same time protect your client's wish, as with our North Carolina lawyer, not to be in a home, not to have a guardian. So the opinion says, before bringing third parties into the situation, the attorney should attempt to determine whether reporting obligations will be triggered or whether the attorney-client privilege will be waived. So we don't have a right answer here. I wish, boy, I could make a mint if I could stand up here and give you right answers and things to always do. But we do have just a little thing to remember when we're thinking about making this report. So let's see, I'm about halfway through. I've probably lost the whole audience, David, but so we'll go to some case studies. Let me talk about what hopefully is going to reflect more of what life looks like for you. Let's start with a new client. And here's my case study. As I read this case study, think in your own mind what red flags are being raised. Okay, so the grandson of Leonora Jones has made an appointment with you, with your office, for her to come in and to discuss changing her estate plan. So they arrive, Leonora and her grandson, whose name is George, and you note that Leonora appears shaky and frail, and she insists that Georgie remain in the office with you and with her. You talk to her a bit, you find that she's a bit confused about who her children are, a bit confused about who her grandchildren are, and then she becomes very emotional. And she says, all of them are trying to steal from me except Georgie. Georgie is the only one whom I can trust. And then Georgie explains to you that she wants to change her estate plan because she wants to add into her will a testamentary trust to benefit her 5 spaniels. And of course, Georgie will be the trustee of this trust. And if there's any money left over when the spaniels die, Georgie will get it. Poor spaniels, not a long life ahead. Okay. What do we see as red flags? Well, we see, David, you want to call on the audience?
Well, one is that he makes the appointment. 2, he's in the room during this. 3, she's shaky and frail. She's telling you this. Where did she hear this from? What is,
right.
Is it just him telling her this? 4, he's the trustee of the trust for the dog and gets everything in the end. So,
in the long term.
Lots of red flags going up when I read this.
Yeah, you did great. I mean, you kind of went right through, just I think like everybody in this room did. A couple of other things to remember is that the victims of elderly abuse are primarily women. And about 2/3 of the sufferers of Alzheimer's are women. And here's the worst part. The highest percentage of abusers are family and caregivers. So as much as we would like to think otherwise, we have to keep that central in our mind. So again, we've got clearly a client who potentially lacks capacity. But all I've said was she's shaky and frail, but somebody else is making the decisions for her. Okay, so the first thing that you have to figure out is whether she has the capacity even to enter into this attorney-client relationship. Now, the model rules give you one kind of out. If things look so bad that there's an imminent danger of something going really wrong, substantially, financially, or bodily harm to her, then you can take action even if she can't enter into the relationship. But your first approach with most of these folks is going to be figuring out if they have the capacity to enter into the relationship. So remember, she's changing her estate plan, another big red flag. If she's coming in to do an estate plan, that's bad enough, but coming in to change one, we've got serious issues. We want to ask her again, why are you making this plan? Why are you changing? What do you expect to be the consequences of this? You want to have her speak to you about these things. And of course, obviously, you don't want Georgie there. You don't want Georgie there. You want to speak to her alone for all of the reasons that I've talked about, and now for what are the very obvious psychological reasons. She's not doing the talking in this conversation. Georgie's doing the talking. In terms of her ability to enter into an attorney-client relationship, some states, and Georgia is one of them, allow people, even people who are under a guardianship or conservatorship, to enter into an attorney-client relationship for the purpose of modifying that guardianship or conservatorship. What our Georgia probate judges recommend is if you are going to take on that kind of representation, that you go to the probate court that has issued the letters of guardianship and just seek an order from them saying that it's all right for the relationship to continue. So the new client is hard enough. Now let's change the facts a little bit. So let's make her a current client, somebody you've treated for a while, or treated or worked with for a while. 3 years ago, she consulted you, and you and she together put into place that estate plan that divided her estate equally among her children. Last year, she came in, she seemed okay. You drafted a durable financial power of attorney, naming her grandson George as her agent. I will say as an aside, on these NAILA professional standards, one of the things that we have debated hotly over and over again is who is your client if George comes in and asks you to draft a power of attorney for his grandmother. And we've talked, I think, about as elder law attorneys, it's very obvious to us that you've got to talk to her. But in any way, you've already represented her here. He's her agent under the financial power of attorney. They appear, we've got the same scenario. And you're saddened by this because in your professional lawyer language, you feel like she's lost it. So you're also concerned about her dependence on George, his eagerness to handle her affairs, and his apparent happiness at being appointed trustee and remainder beneficiary. So first question that comes up, remember agency law? That was boring. But basically one of the things that agency law taught us was when the principal becomes incapacitated, the agency terminates. So if she, in fact, has become incapacitated, has your attorney-client relationship terminated? Well, the restatement of the law governing lawyers and the restatement of the law of agency have recently realized that if that were the case, these people would not have attorneys at all. And so they are working on a way of having the agency relationship continue even if there is a loss of capacity on the part of the principal. The model rule, 1.14, seems to presume that you'll continue your normal attorney-client relationship. And the ACTEC commentaries say that you may be considered to continue to represent the client even if a fiduciary, a guardian, for example, has been appointed for that person. You may competently and appropriately continue the representation. Now, lots of times the guardian or conservator is going to come in and say, you're out in terms of you don't represent her anymore, you're working with me from now on. But the commentaries make it clear, I think the model rule makes it clear, that the presumption is that you will continue to represent her. So maybe you're really uncomfortable with this and you say, I think I got to withdraw. Can you withdraw? Tim?
Mary, I have a question. Mm-hmm. I guess I have a question about your fact pattern, and that is that Leonora comes in, she does her estate planning with you, say in 2013, and maybe has signed powers of attorney naming George, grandson, as her attorney in fact. And then he comes in 2014 or 2015. Now, in my view, Leonora is a former client. She is not a current client to whom you owe duties. In other words, the representation has ended, and now you have certain duties to former clients.
Well, that's great because it's exactly the kind of thing that we've been debating with the NAILA aspirational standards. The attitude of some people is unless you have terminated that relationship, and I probably should have indicated that you haven't, that you continue to represent her. Now, but you're taking the approach that the attorney had done what probably would have been the smartest thing, which would be to give an exit letter and say,
Well, here's one thing I have some experience with the aspirational standards because when I went on the NAILA board in 2004, they were presented for a discussion, the original, for an approval. And one of the suggestions that I made, which fortunately that was taken up is that the aspirational standards that were presented to the board had all of the stuff in there, but it did not have anything in there about it talked about what should be in an engagement agreement.
Right.
But it did not say how the engagement agreement ends, the representation ends. And I recommended that it needed to be in there. So in my view, if you have a representation that is where the scope, where the work is done, an exit or an end of representation letter is not necessary.
Right. If it was very clear from the engagement letter itself.
Right. And that should be an aspirational standard because it was put in there because they realized that that the original draft was deficient, at least in that.
What my experience has been more from an estate planning standpoint is that estate planners are very reluctant to end the relationship. They want to, they consider themselves long-term family lawyers.
Gotcha.
And again,
understandable.
Yeah, right. And it's not. I mean, it's not out of greed. It's more out of these are my clients, and I'm going to deal with my clients, with life changes, things like that.
Yeah.
So, but you're right. I guess you're. Well, let me back up a minute.
I guess my example would be more. Let's say that Leonora comes to you. You done work for her in 2013, and then she comes back in 2014. Maybe there's some change, maybe she has a little bit more confusion, but you enter into an attorney-client relationship then, or another engagement agreement to do something else, and then maybe 3 months before that's concluded, George comes in and says, well, here's what's going on with Grandma. Now what do you do?
Right. Right. And again, if you're taking the attitude that she's a former client, and the approach I'm taking is she still is your
Right.
client.
Mm-hmm.
And so there's something for us to think about.
Right.
You know, do we want, in order to protect or to make clean, I guess, the situation, do we want to make sure that she knows she's not our client anymore?
I mean, I tend to prefer ex-clients. Or former clients.
Former clients, right.
It makes things a lot cleaner because then you don't run across some of those issues that you've addressed.
It makes it cleaner for the lawyer, but I worry about the client.
Yeah.
Yeah, so I mean, it's what we always face. I mean, at least all of us who deal in a humane law practice as opposed to some of the other folks, where it's just easy to say this is done. But thank you, I appreciate those comments very much. In terms of the withdrawal from representation, the model rules actually point out that this withdrawal from representation this time, while it might help the lawyer, is probably going to leave the client completely helpless. Because as you pointed out, now you have a client who's not able to get into another attorney-client relationship. Another problem that comes up here, what if Georgie basically says to you, look, if you don't do this, I'm getting somebody else who will, and says, on behalf of my grandmother, I'm firing you, and give me all the files. Now, we know that if one of your clients leaves you and goes to another attorney, you're supposed to give the files to that other attorney. The Massachusetts bar looked at this, and it actually said that even though you should normally turn over the client's files, when the circumstances indicate to you that the client may not really have had the capacity to make an adequate decision about terminating your relationship, and you believe that the client is at risk, again, of this financial, substantial, or physical harm, that you may consult other members of the family or others who might be more helpful before you immediately turn those files over. And you've probably had this happen to you. I've had lawyers call me up and say, what do I do? I know fully well that she is not capable of entering into that new client relationship. I know that Georgie set up that new attorney-client relationship because he wants to get what he wants. What do I do? And so again, at least this opinion gives us a notion that we call our whoever you call in your state to get your bar opinions, but talk about the fact that there's some precedents for not turning over in that situation. Okay, let's assume that we've decided, though, that even though Leonora is frail, we're in our attorney-client relationship, so she still may have capacity to enter into certain transactions. Here's where, again, it gets shaky and scary because states don't even agree as to what kind of capacity is required to do what thing. For example, in Georgia, in order to set up a testamentary trust, all you have to have, of course, is testamentary capacity, which is fairly low level. But to set up an inter vivos trust, you have to have a much higher level of capacity. We just go pretty much across the border to North Carolina, and in order to enter into a irrevocable trust, which they use as a will substitute, you only have to have testamentary capacity. So you've got to be really clear as to your own state law as to what kind of capacity is at issue at this point in time. Of course, if this ever ends up with a jury, it's virtually impossible for a jury to understand how you could have the capacity to do one thing and not to do the other. So do you have a duty when people, yeah.
We do have some litigators in the room.
Oh, I'm sorry.
If you want to put them on the spot.
Mea culpa. I love litigators. Some of my best friends are litigators, yes. Did you want to put them on the spot?
No.
Did they want to say anything?
I don't know if they, I guess they can raise their hands, but...
They're litigators, David. They can take care of themselves.
Yeah. As you've been going through this, I'm thinking they may be listening to you, thinking about their next trial.
Well, there's that possibility, too. Consult David. Well, here's a question, I guess, for the litigators, because that's where it's come from. Do you have a duty to assess client capacity? Do we know? Well, the cases say you do. The cases say that you do. You have a duty to, particularly when somebody's coming in to modify a longstanding plan. And the ACTEC commentaries kind of put it this way. If you don't think somebody has that capacity, then you probably shouldn't go through with the transaction. But if it's a borderline situation, then be very careful because you might be robbing that individual of his or her ability to make a necessary, needed, or wanted change just because you don't think that person has capacity. There are cases out of a lot of states that talk about this duty, and they usually phrase it as a duty to make reasonable inquiry. So it's not a duty to run all the tests and to, in most cases, probably not a duty to send somebody out for an evaluation, but definitely the cases in states across the board are really clear about the fact that you do have to make that inquiry. So how do you do it? How do you do it? I mean, we all know, I know, we are not trained. There are people who are trained to do that. But many, many lawyers just take what they call the common sense approach. I know it when I see it. I know it when I see it. And again, I caution you, I know lawyers do that. Be aware of your ageist tendencies, which we all seem to have, that the decision to collect a bunch of dolls and dress them in designer clothes made by a 104-year-old woman might be deemed differently than the decision maybe to invest in the stock market made by a 35-year-old white male, okay, which a lot of people are doing, myself included, unfortunately, right now. But the important key to remember is bad judgment is not lack of judgment. Bad judgment is not lack of judgment. On pages 28 through 29, I have some just observable things, signs of diminished capacity. But I want to take you to page 29 to another possibility, and that's a referral or a consultation with somebody else. Now, a referral with family members we've already talked about. We've got that 1.6 confidentiality problem that we need to look at. Limited disclosure of your observations may be appropriate in these circumstances. One thing that I think many lawyers have not considered doing yet is developing a relationship with a forensic evaluator, and you yourself, the lawyer, going to the evaluator anonymously, not naming your client and not giving enough information to disclose confidential information, and asking for an evaluation. Usually you'll pay for that, which might be why a lot of lawyers have decided not to do that. But since you're paying for it, the client's consent is not needed. It might be worthwhile to suggest a medical exam, because as we talked about early on, there are lots of possible things that could be causing what you're perceiving as a lack of capacity that could be treated, even something as simple as changing, the drug interactions. The formal forensic capacity evaluation is the one that I mentioned before. The advantages of that, obviously, are now you have a neutral. You have somebody you will have something in the record. These forensic evaluators are exactly that. They are trained both in the medical aspects, but also in what they're looking for legally. And you still, at the same time, have the responsibility to spell out in your letter to the evaluator, this is the transaction that the client is considering. This is the level of capacity that's needed. Here's how it's described in the law. Please help me to wed your findings with everything there. The disadvantage, of course, the expense, the trauma for some people. There are often litigators. Were the litigators over here? Am I appropriate in pointing to them? Yes.
Oh, these are.
Yeah, and if I have an evaluation, a forensic evaluation of one client, what are you going to ask me on the stand? Do you do that with every client? What was wrong with the client that made you think she needed to be evaluated? I mean, lots of lawyers say it's too dangerous to do that because they would either have to do them for everybody or not. But you litigators can figure that out. The thing to remember, though, again, is that the legal capacity assessment ultimately is yours. Even though you've gone to a third party for an assessment, you need to make the final call legally. Now, there's some possibilities that are not nice to contemplate. Suppose that the evaluation yields something that your client has said, if you tell me that comes back that I have Alzheimer's, I'm going to kill myself. Well, there are some commentators to the model rules that say that if there is information that you gain in the course of an evaluation that is so traumatic that it could harm the client, that perhaps you don't need to reveal that information. I don't know where they're finding the source for that. That's a very, very difficult call to make. So on page 32, as I promised, here's a list of items that I've collected from a variety of lawyers who deal with not only older clients, but with other clients who have diminishing capacity, who tell me that lots of times we as lawyers are missing the chance to enhance the capacity of someone so that that individual is at his or her best and is able to make an appropriately legally binding decision. Short meetings, multiple short meetings, rather than the one long, dreadfully boring meeting that most of us do with our intake. Multiple short meetings and asking the same questions at all of those meetings to make sure that there's consistency. The time of day of the meeting, can be important. As so many of you know, there are certain times of day, the so-called sundowner syndrome, when people are less coherent and less able to think. Little physical things like bright lighting, minimal background noise, don't have your phones ringing, don't have your assistants jumping in every 2 minutes to tell you have an important call. Speak clearly when facing the client. I just read an article the other day that was great about how most people do not know how to speak clearly and in a moderate voice when they're speaking with someone whom they feel is not hearing for either lack of capacity or lack of physical capacity. And the article pointed out that people tend to yell then at that person, and it scares the person, and then back again into some kind of perception of the person lacking capacity. Don't finish the client's sentences for her. We all tend to do that for each other. Avoid using legal terms without explaining them. Well, that's kind of a rule for everybody. One lawyer I know draws diagrams. She's an estate planner, and she's got great diagrams that she uses to indicate the alternatives, the possible ways that the client's estate can be divided. And then she asks her client to reiterate what each of these does, and then to say why she's chosen the one that she's chosen. Allow ample time to review the documents, both in the lawyer's office and at home. As Tim, I think you pointed out, meet with the client at home or at whatever facility where the client is living. The clients are often a lot more comfortable there, and it's too traumatic to get through the process just of getting into a car, let alone the traumatic process of going to see a lawyer. And without consulting confidential information, it is possible to talk to the family members about things like what's the best time to speak with your mother, what kind of medications is she taking, are those medications, do they click in at a certain point in time and maybe cause either coherency or a lack of coherency. Those are good ways, again, to involve the family members without involving them in the confidential information itself. Now, the big question, I suppose, for us as lawyers, are we liable to a beneficiary or a beneficiary who's been cut out for allowing a client to enter into a transaction that the client might not have had capacity to enter into? So you know what's going to happen. What happened in the case of Huguette Clark? What happens in the case whenever family members are knocked out of the will? First, there's going to be a challenge to the will itself. Next, if the family members lose, they're going to sue the lawyer. They're going to say, you should have known. You should have figured out that my mother lacked capacity. All of these signs were there, and you didn't follow those. You still wrote that will for her, and I'm getting my inheritance, but I just had to spend $60,000 in lawyer's fees getting that.
It was a good investment.
Sue the lawyer. Yeah. Right, David. I taught you well. Okay. Well, the good news is that the cases that have looked at this say that we do not have a duty to third parties to assess our client's capacity. We have a duty to the client, but it's a duty only to the client. And to extend that duty to third parties would be causing the lawyer's loyalties and ability to act to perhaps be so distracted by those third parties that the lawyer will not focus on what we've been talking about here, which is making sure that your client gets what your client wants. The bad news, of course, is that the so-called privity door keeps getting open wider and wider and wider in many states, and we may, in fact, end up with a case in which the beneficiaries are allowed to sue the lawyer, even though the lawyer was not their lawyer, because the lawyer allowed this to happen. So what about the protective action? I'll just talk about that briefly before we finish up. Remember, in these emergency situations, you're supposed to take protective action. Well, what can you do? The ABA and the cases that I cite for you here always focus on the fact that there are two words in front of protective action: reasonably necessary. And the ABA translates those into the least restrictive action possible. So, for example, if it's possible to resolve something with perhaps a limited guardianship, or maybe just a guardian ad litem appointed for a certain situation, don't go the full-blown guardianship or conservatorship route. The emphasis is constantly on making sure, to the degree possible, that you retain for the client's independence. So can you seek a guardianship for your client? Now you've gotten Lenora, and you know she's about to get really ripped off by Georgie, and Georgie's already told you that if you won't do it, he's going to go out and get a lawyer who does. Can you seek a guardianship for your client? Well, again, the answers vary across the board. the basic approach seems to be that you first have to make the assessment. You don't let somebody else come in and say to you, Grandma needs, your current client, Grandma needs a guardian. So the assessment has to be made by you. You can later eventually represent a person whom you've suggested as guardian to the court, but you should tell the court up front whatever your relationship is with that individual, and make sure that the court understands that you might end up actually getting some money later because of this guardianship. And finally, the rules end by saying you should rarely have yourself appointed as guardian, which not only makes sense ethically, professionally, but personally. I know many of you have probably had people who've come to you and said, there's nobody else, there's nobody else. A lawyer serving as a fiduciary, that's next year's conference, David. I mean, there are so many complications involved there. So with that, I leave you at the end of the outline with some really bad cases about some really bad things that lawyers have done. But the thing that strikes me in these cases, and I see it over and over again, is these are lawyers who've been in practice for 35 or 40 years. It's not new young lawyers making the wrong decision. And I don't know what happens. Part of it, I suspect, is that sometimes people who've had a tough business financial practice decide that they're going to go into elder law in their retirement, and they don't know what they're doing. Part of it is, I'm afraid, that people who represent vulnerable people, particularly vulnerable seniors, tend to try to take over, and sometimes that taking over bleeds over into taking away from that person. So I thank you for your attention, for your comments, and don't call me to consult on your litigation, because David will never let me forget it. And we'll have a good lunch and another good discussion with Tim. Thanks.